Welcome to Dad Talk Today. The podcast for dads facing some of the toughest moments of their lives. We are here to walk with men through divorce, keep them connected to their kids, help them understand their rights, and work for change in family law courts. Moms, you are always welcome too. We are all about advocating for shared parenting and doing what is best for our kids. Here is your host, Eric Carroll.
Everybody, welcome to Dad Talk Today. I'm joined tonight with Attorney Kevin Hickey. Kevin, what's going on, man?
Hey, man, how's it going? Just another Monday, you know?
Yeah, it's another case of the Mondays. We got an exciting week coming up. Team's going to CPAC, going to be doing some media and looking forward to doing a lot of lives with you guys. Well, tonight, I've been getting a lot of questions. You know, the case with John has brought a lot of attention that we didn't, we've always had a pretty big show, but it's been getting a lot of new eyeballs and people wanting to know what's going on. And people have been asking us questions, you know, what to do in my case here, what, you know, been getting all kinds of stuff. So me and Kevin are going to start this. I think it's going to be every other week. If you got questions about your case, parental alienation, false allegations, guys, write them to us in the comments. And I'll bring in Kevin. I think it's really important to note nothing about this creates a client-attorney relationship. Even though Kevin is a professional attorney, he's not becoming your lawyer, okay? So this is just his opinions, and we'll try to answer them as good as we can. But before we get into that, if you'll start lining up the questions, I'll get to them as soon as we can. But Kevin, what do you think is the number one mistake people make when trying to get or trying to prove parental alienation in a family law court case?
And one thing I want to add to what you just said, Eric, is every state is different on the laws. So be sure when we talk about different cases and different situations, I'll try to remind people of that I'll give general ideas, but you always want to check with a lawyer in your own state because the laws are different state to state. What was your question again on parental alienation?
I said, what do you think is the most common mistake that alienated parents do when going into family court?
I think they've been living it.
My bad.
That's all right. They've been living it. So I think the biggest mistake is they're going to go in and the judge is just going to immediately understand, number one, what alienation is and to be able to recognize it. You've really got to put a roadmap out there. Text messages that have been sent to you, denying visitation, emails, phone calls, phone messages, through our family wizard, or if you use another family communication device or software, you've got to show that judge. Don't go into court thinking the judge is just going to get it. You've really got to lay that roadmap out for them.
Right. Gotcha. We got a few questions coming in here, guys. Put them down in the comments and I will get to them. Hunter Butler said, how does a father representing himself find the proper court laws for family court? Never married, especially alienation, neglect, and contempt of court, Missouri here.
I think he's wanting to know how to look up the laws.
Yeah. Mm-hmm.
I think I tell you, one of the best ways, and it's free, is Google Scholar. Google Scholar will give you a ton of information. It'll give you a ton of cases, and you can narrow it down by state. So I think it says you're in Missouri. You could narrow it down to Missouri and look it up that way.
Right. So check that out. I appreciate that question, man. Blue here on YouTube said, what do you do if you have a crooked, evil gal on the case? You know, guardian ad litem's don't seem to have too many fans nowadays.
You know, guardian ad litem's are great when they're on your side, and they're not when they're not. And they do get a very bad rap, it seems like. You have to be careful with a guardian ad litem, and I don't know how far you are into your case. You're not alone. A lot of people feel like the guardian ad litem is either against them or not being fair, not really listening to them. If you're having consistent problems like that, you need to talk to your attorney about what to do about it. About all you can do is try to get a different guardian ad litem. You're going to have to file that with the court. And so you're kind of putting everyone on notice that you have an issue with this ad litem. And if it backfires and you don't get a new ad litem, you're still stuck with this one. So you're really walking a fine line when you try to do that.
Gotcha. Hey, appreciate that. Blue. Winford on YouTube said, why is familiar, I think they meant to say family, why is family court so dependent on the judge in terms of the outcomes and decisions?
That is, let's say you go to a divorce or a custody final hearing and you lose and you want to appeal it. You'll appeal it up to the Court of Appeals or the Supreme Court of that state. And one phrase you will see over and over in the Court of Appeals or the Supreme Court's decisions is, we defer to the trial court. We defer to the family court judge. And one of the biggest reasons is because they are the boots on the ground. They got to see the witnesses testify. They got to see a real person. They got to judge credibility. They got to hear all of that in the courtroom. The Court of Appeals, all they get is a black and white transcript of what happened. And then there's exhibits or whatever that maybe were introduced. But by and large, they don't get to see people. They're reading a transcript of what happened. So the laws are set up to really give the trial court judges a lot of discretion to decide, because they are the boots on the ground.
Gotcha. Hey, appreciate that. Sean Van Levine, I hope I said that right. He said, how do you prove lack of effort to try and co-parent from mom?
Well, that's where your documentation comes in. If you're using Our Family Wizard, and I keep saying that one, that's a very popular program that parents use that have divorced for setting up custody issues, visitation times, doctor's appointments, and things like that. Get those records and show that you were trying to co-parent. You were trying to ask questions. You were trying to make decisions together, and mom was consistently refusing to do that. Text messages, emails, voicemails. You know, I tell clients to get a calendar, a little diary in a book, and all it is for that, at the beginning of a case, all it is for that case, and document on that day what happened. It's much easier if you have a calendar to write it in, or you can do it computerized too. But if you write it down on that day, you don't have to worry about remembering the date or when did that happen. You're keeping track of it as you go along.
Hey, Sean, appreciate that, man. C1 here on YouTube said, Eric and Kevin, do you guys think that parental alienation will be illegal in all states sometime in the future? I would like to see it illegal. You know, it's got to be proven that it's parental alienation, because you know, anybody can just throw that false allegation out there. But we know that it's happening so often.
And parental alienation has so many levels to it. When you talk about it being illegal, to me, that means, is it going to be a crime? One thing to remember, pretty much every state has laws against interfering with custody and interfering with visitation. So if the other parent is preventing your visitation time or interfering with your custody time, in most states, that is a crime already. And that's a type of alienation. And so you can go to the prosecutor about it if you have consistent problems.
Absolutely. Hey, appreciate that, my man. Let me see. Stephanie Bradbury said, what is the best rebuttal in court when the other parent tells the judge that the child didn't want to visit alienated parent, even if it clearly states in our judgment, not choice of child?
Well, you get into a sticky situation when you're dealing with that, because usually your best witness is the child. And I always leave it up to the parents. It's always a very difficult decision whether you want to put a child on the stand or not. Some judges are okay with it. Some judges absolutely do not want that to happen. So the child is usually your best witness. Now, if you have an ad litem involved, sometimes the ad litem can share certain information with the court about what the child has told them. But then you run into some hearsay rules there too. So there's a little bit of an issue with that. The only way you can really combat it is confront the other parent with information. What does the child tell you when the child's with you? You know, you're the alienated parent. Is the child saying, I really want to be over here? Mommy tells me not to talk to you. Mommy says to act this way with you. That's about the only way you can really rebut it, is try to get your documentation together and gather your own evidence of what you're observing.
There you go. Thank you for that, Stephanie. We got one from Linnell Davis Jr. He said, what do you think of rebuttal presumption? I think he's talking about a rebuttable presumption of shared parenting.
That's probably And Eric and I have actually talked quite a bit about this, and I'm always okay with a shared parenting law as long as there's this rebuttable presumption in it. I think it needs to be in there. We can't just assume that every parent is doing a good job and is doing okay as a parent. We have to have some mechanism there for the court to be able to say, parent A over here is not doing anywhere near what needs to be done as far as what parent B is doing. And there needs to be a mechanism for the judge to look at that and say, I don't know that we need to do 50-50 in this situation.
Absolutely. Stephen Creasy said, what can I do in North Carolina? I'll go ahead and save Kevin a little bit of time. He's already said that he's just practicing in Arkansas. So again, he's giving you his best opinion, but what can I do if my ex won't let me see my kid and started a child support case and I done my DNA, but she didn't cooperate with child support, so they dropped it and we've never been to court?
Okay, I'm not sure about North Carolina, but most states, it sounds like what she's done, and I'm assuming you guys were not married. That's why you're needing to do a DNA test. In Arkansas, if you're not married and a child is born, the mother automatically has all custody rights, and the father has to file a paternity action to get his rights established. And many times there's a DNA test involved in that. A lot of times paternity cases get started by child support enforcement. It's called child support enforcement in Arkansas, whatever your child support enforcement agency is in North Carolina. It sounds like mom opened a case or tried to open a case with them, and then it got dropped. And when that happened, child support enforcement, those agencies, they usually don't care about your visitation or custody. All they're doing is trying to set up child support. So when that case got dropped, it sounds like maybe your whole process got dropped. DNA, you were probably wanting to do these other things with visitation, and it just all got dropped. You'll have to file that on your own. You can file your own paternity action and get your visitation set up or custody or whatever else you want to ask about.
Absolutely. Hey, Stephen, thank you for that question, man. Loanne Russian said, when talking about my son's case, I never mention his name or the mother's name, but my family is nervous about me talking about the story because the mother is so litigious. What are our rights so we don't get sued for libel or slander? That's a good question.
That is a very good question. And always remember, libel and slander fall under the name defamation. Libel is written and slander is spoken. If you're telling the truth, it's not libel or slander. The bigger concern I have is children can be incredibly truthful, and if a child either tells the ad litem or tells a judge, dad's and his family's talking about this and that and everything else, that can really hurt your case, because then it looks like you're trying to taint the child's image of the other parent. So that's what I'd be probably a little more worried about than libel or slander.
There you go. Hey, thanks, Loanne. Antonio Gilchrist said, why is it so hard for dads to get full custody if you make all of the income?
Most states have and some of it's kind of a gray area and unwritten. And in some states, like in North Dakota, for example, they have about a 15-step process of what the judge is supposed to look at, different factors in making his decision. And income is only one factor. So income is important, and it's good if you can show the court that you make a very good income and can provide a very good a very good environment for this child. But that's just one factor. And as far as the dad thing, I think we're just coming out of an age, for decades. I mean, moms had a stronger case for custody. They were usually the stay-at-home moms, and we're just in a different era now. And technology in our world has kind of moved a little faster, I think, than the law has. That's just kind of my opinion.
Absolutely. Christopher Hilliard said, what can I do if my children's mother is not sending my children to school when they are in her care? We have 50-50 custody.
Well, I get calls from people, and this is something like that has happened once or twice, and I tell them, let's don't go back to court yet. Let's see if we can solve that either by writing a letter to the other attorney, or if the case is over, writing a letter to the other parent directly and just saying, look, we've noticed this, and this is obviously not in the best interest of the child. We need you to get this corrected. But if you've got a pattern that's gone on for a while, or you've sent a letter like that and nothing's happened, you just have to go back to court. I mean, that both parents are charged with making sure they take care of the best interests of the children. If one parent's not doing that, they're either in contempt of the orders, or you may need to modify the visitation or custody.
Absolutely. iTumblers. This is
Eric, can I add one thing to that?
Yep.
When we first look at a custody case and somebody wanting to change custody, one of the biggest indicators we look at is school performance. And there's at least two parts of that. There's their grades, how are their grades, and how their grades been doing over the last year or 2 years. Excuse me. And how's their behavior? Has their behavior really gone downhill since they've been placed with the other parent? So school is something, and if a parent's not taking a child to school, sometimes there's more to it than just being a few minutes late. Maybe something else is happening in that parent's life that's causing that. So school is very important.
Gotcha. This is a pretty interesting question right here. iTumbler said, do you think there's a way to improve family law through the two-party political system? This issue really transcends political lines. Family law lacks a lot of common sense.
I definitely agree with that middle sentence. It definitely transcends political lines. And I know a lot of times there's a lot of things that just don't make sense in the family law system. Getting some kind of family law improved through a two-party political system, I think that'd be very hard. For one thing, family law rules are largely by state. So every state is going to be different. But I will say that as far as alienation, shared parenting, those kinds of things, the best way to get some change is through some kind of legislation to start chipping away at these problems we have.
Right. The two-party political system, sometimes they'll agree with it. I've seen in states where there's bipartisan support, and then it becomes which party is going to do what, and then they start taking sides, and then it just kind of goes away, man. It's hard to get anything done in this two-party political system in today's atmosphere, to be honest with you. I don't know, but we're going to continue trying. And that's the best I can tell you, getting out there, having conversations with them, and doing what we're doing here, guys. And I appreciate that question. Lee Carter said, in what state is Kevin practicing? How backed up is his state's family court?
I am in Arkansas. That's a good question. It depends on the length of the hearing you're wanting. If you have a half-day final hearing, you can get into court. I hope there aren't any Arkansas attorneys looking at this and saying, "Oh my God, what's he talking about?" Usually, it's a few months before you can get into court. If you're wanting all day, and definitely if you're wanting more than one day, you're going to be probably several months. Now, if you file your custody case, let's say today, you don't immediately ask for a hearing. So usually you go through some discovery. The other side has 20 or 30 days to answer in most states. So you got to wait for that time. Then you do the discovery that's 30 days or longer. So then you start asking for a final hearing. So from the time you file until you get into the final hearing is usually several months. It can be faster than that.
Gotcha. Jason Alex said, what if mom is still using, and I'm guessing he's saying substance abuse. What if mom is still using and CPS is siding with me?
Well, if CPS is siding with you, that's usually if you've got a juvenile case or CPS case going on, that's usually the biggest hurdle we've got, is we're trying to fight CPS all along the way. So if they're already on your side and mom is using, they should have some kind of parameters set up through the court that she's having to regularly drug test. If they don't, your attorney may want to ask for something like that.
Yep. Gotcha. Okay. Luis Fargas said, I have joint custody with my ex-wife and my 4 kids, and she wants to send my daughter to Florida with her uncle and his wife and her 21-year-old brother that I don't know. Do I have right to say no? She can't go, and if she does go without my permission, what should I do?
So it's sounding like mom is going to stay there, and she's going to send the daughter uh, with her uncle and his wife. And 21
That's what
years
it looks
later.
like. Yep.
Well, they don't have any rights to the child. I mean, you're the father, so if mom's not going to have the child with her, and this is some kind of permanent arrangement she's trying to put together, I mean, the child needs to go to you. So you may want to talk with an attorney about that.
Gotcha. Stephanie Bradbury said, "Is enforcement better to ask for than contempt if it has been 2 or 3 years of alienation?"
That's a really good question, and it depends. A lot of times we ask for both. In fact, I just drafted a motion in a case today that asked for both contempt and enforcement. That way, if you're denied on one part, you still have your other part alive. Because contempt, judges, they don't want to try to jump to the contempt level unless they really feel like they've got a parent that's acting poorly. Or they'll say the first time around, they'll tell them they find them in contempt, and then, but their punishment is they're just going to warn them not to act that way anymore. So I usually ask for both, just in case the judge doesn't think it rises to the level of contempt. They may still do something about your enforcement motion.
Gotcha. Lee Carta said, "Are states funding family courts to function properly? Timely due process of law?"
I have not. I would really be speculating on that. I haven't looked at any research on that as far as funding. Certainly not outside the state of Arkansas. I haven't. I think most states are doing a pretty good job of moving cases along, but I couldn't. I don't know.
I can't say I do either, man. Each state is different, but we will definitely check into that. Hunter Butler said, "What would be good cause for keeping a child from the other parent?"
Well, there's probably a laundry list. We could probably talk for 2 hours on that. Drug use, if there's significant drug use or abuse on one side, alcohol, neglect, any kind of physical abuse, sexual abuse, emotional abuse. There's a lot of reasons that would give good cause. Now, if you've got a court order in place and the other parent is keeping the child from you, or you're keeping the child from the other parent, understand you're probably violating that order and could be in contempt. If something's consistently going on with the other parent and something needs to be done about not letting the child go over there, you need to file something with the court to get the order changed.
Gotcha. All right, this is an interesting question. iTumbler said, "I just got back with the alienating parent. Any tips or suggestions to convince her to improve the court order, child support, parenting time?" I mean this in the best possible way possible. Why would you get back with an alienating parent? That's actually the very first lawyer I talked to, Kevin, that was his suggestion. It was cheaper to keep her. You need to find a way to get back with her. What would be your suggestion on that?
Well, I've kind of got the same question you do. And I'd be, well, I don't want to say that, but it concerns me about their relationship. I mean, if this was true alienation going on and now they're back together, yeah, they need to go to counseling or something to try to work through that. Yeah, as far as the court order, you gotta understand that court order was put in place for planning on the two of you not being together, and so these are the ground rules you're going to play by. If you're going to be back together for a long time, you need to be careful. Like if you stop paying your child support, and you guys break up months down the road, you don't want the other parent to say, "Well, he didn't pay child support for 8 months" or something like that. So there's things to consider in that situation.
It's good advice, man, because I would almost guarantee you somebody like that, if they is alienating you from your child, they'll pull that, and there's a good chance that it's not going to last. I wish you nothing but the best. I love to see when couples can actually make it through. Divorce should be like a last area of resort, but sometimes it has to happen. So wish you nothing but the best of luck with that. Lee Carter said, "What to do if false allegations are directed to a separate court, such as criminal court, separated from family court?"
Well, And that is a very good question, because when these false allegations come up, many things can be triggered. Many agencies can be triggered into action. You can have your family court case where the allegations can come up and hurt your chances in that case. You can have a CPS case opened up, or what we call in Arkansas the Child Maltreatment Registry. They could open a case in your state. Pretty much every state has one of those registries where they can be put on there, where a person can be put on there for child maltreatment. So you might be fighting a case in that agency's division. And then you could have a criminal case start. You could be arrested for some kind of assault or battery. And I think what you're talking about is if you go to if it goes to the criminal court, the prosecutor will decide whether to prosecute you or not. And if they start a case, you're going to have to defend a criminal case.
All right. Blue on YouTube said, "What about twisted truth? How do we go about proving that?"
Okay, you're going to have to educate me, Eric. What does he mean, twisted truth?
I was hoping you knew. Blue, go down there and put it in the comments. We'll be here for a little bit longer. If you could explain that a little bit further, and we'll try to get into it. Eccentrics Futile on Facebook said, "In Ohio, the mother automatically is granted custody if the couple isn't married. My son's mother left us when he was 8 months old. I've been raising him by myself. We have a verbal agreement to do shared parenting, but she rarely comes through for my son. She gets on power trips and threatens to take him away sometimes. How do I take her guardianship away? How do I protect my son? Should I go to the courthouse and tell them what's happening? I can't live like this." And then it cut off the rest. But what would you say about that there, Kevin?
Well, he changed there toward the end and said, "How do I take her guardianship away?" A guardian, he may just mean her rights as custodian since the child was born, because a guardianship would be a whole separate filing. You need to get with an attorney immediately, and you need to get custody placed with yourself. It sounds like you've been raising that child for a long time, and if you haven't filed anything to establish your paternity, I would be concerned about her trying to take off with the child. So I think you need to get with an attorney and file something as soon as you can.
There you go. Stephen Cobb said, "Can you have mother and children deposed? And if the mother tries to withdraw their petition for custody based on allegations, false by the way, from criminal court?"
As far as depositions, yes, you can. Again, with children, it's a slippery slope. You've got to be careful with that. And it's always a decision that I really talk through with the parent that I'm representing, if that's something we really want to do or not. I don't know about that last part. If the mother tries to withdraw their petition for custody based on allegations from criminal court, I'm not sure what that's asking there.
All right, Stephen, I'd say the same to you as Blue. Get us down in there in the comments, and hopefully I'll have time to re-answer that one. Jacob Mateer, just want to say thank you guys for joining the broadcast tonight. A lot of new faces that we haven't talked to. We are glad you're here. He said, "In Indiana, I am currently going through a divorce. I wouldn't leave the marital home because I wasn't going to leave my son. She got the magistrate to order me out of the house. I am now paying child support and all marital bills for her to stay in the house. At the time, she was a stay-at-home mom. Is this legal for me to pay child support and all the bills? Isn't that what child support is for?"
It sounds like after the divorce was filed, you had some kind of temporary hearing. And many times judges will do that to kind of set ground rules. As we were talking earlier, it could be several months before you have your final hearing. And everybody's kind of in limbo if there's no order put in place to put ground rules and boundaries on the parents and how everybody's going to act and who's going to pay for what until we go to the final hearing. So it sounds like you had a temporary hearing and the judge allowed her to stay in the house. And I'm guessing maybe you have more income than she does. And so the judge decided to have you pay the bills on the house. If that's the case, talk to your attorney. You've still got the final hearing is the big hearing. These temporary hearings are just to kind of put parameters on the parties for a while. So you've still got a chance to present your whole case at the final hearing.
There you go. Lek Sari on YouTube said, "How do I deal with my spouse who accuses me in petitions of the very behavior she is guilty of?"
You've got to prove it. And this is something that's hard. And attorneys deal with it all the time, and the general public does not. You read something in writing that the other side has filed, or the other attorney, or whoever, and you immediately read it as true, and that it's everybody believes this, and it's hard to understand. Those are just allegations. They've got to prove those allegations. So when they go to court, she can say whatever she wants, but she's got to have proof. And so the best way that you can counter that is with your proof, and to show that it didn't happen. And you'll have plenty of time to get your case together before you do that.
Gotcha. Andrea Sterling said, "What can my husband do if his baby mother is not allowing him to speak to his daughter, and he is not able to communicate with her because she has him blocked? Custody is to split, where he is supposed to get her to school breaks in summer."
Well, there should be it sounds like they've already got a custody and visitation order, and most of those, not always, but most of them provide a schedule for telephone visitation or FaceTime or some other kind of virtual visitation. And if mom's not complying with that, you need to do something about it. Write her a letter, have an attorney write her a letter, and say, if this behavior doesn't get better soon, then we're gonna have to go back to court because you're violating the order.
Gotcha. Nick Dion said, "What can we so about a mother who has a boyfriend who has a history of battery charges and believe he is the new father and has physically disciplined each child in ways that are worse than spanking, and it's possible to prove a way the children are living in an unstable environment?" I tell you what, I hate to hear of any step parent spanking a child or being any type of physical situation. I believe that is to the biological parents. I just had to say that. I'll let you take that though, Kevin.
No, I agree with that. It's always problematic when the step parent tries to do some type of physical or corporal punishment. And judges will generally, at least the judges I deal with, will generally say that needs to be left to the biological parent in each household. As far as the history of battery charges, believes he's the new father. It sounds like he's kind of domineering in that house. Either he's telling the children to refer to him as that, or mom's letting it happen. I don't know. But you just have to get all the information that you can through your evidence, text, emails, family wizard, anything the children may tell you to prove what's going on in that house. I'm surprised CPS hasn't gotten involved based on some of the stuff that he's saying has happened. But that's all you can do.
All right, so we got the other side of this right after this, and it's not as much as a legal question, but I guess it kind of plays into what Nick was asking. David Miles said, "I'm having a hard time trying to get my stepdaughter to listen to me, and tonight, after a whipping tonight, she asked me why I don't love her, and it has my heart broken to a million pieces. I'm in Florida, by the way. What can I do?"
Well, yeah, that's sounds like more of a counseling type issue. I think the more you can get your wife involved, since it's her daughter, I think that's about all you can try to do, and get her to help you with talking with your stepdaughter and trying to work through that.
Gotcha. Blue asked another question down here. She said, "What if your ex is mentally ill, and I don't mean just bipolar disorder? What recourse could I take?"
You need to have the court. Well, if there's a case going on, you need to try to have the court order a mental examination, because you're going to need to be able to prove that in court, and just your testimony is not going to be enough. You're going to either need medical records establishing what his diagnosis is, or you're going to need a professional to give an evaluation.
Yeah, and I think that's a really common thing. Not saying that's what you're doing by no means, Blue, but I have a lot of parents come in there. My ex is a narcissist. They got bipolar disorder. It's like, dude, you got papers to show that? You can't just go tell that to the court. You got to be able to show it down on paper, and that a doctor has said this is what's going on.
Right.
So everything that goes down in court, guys, you got to be able to prove it.
Well, and the reason I say that, because I know a lot of people may be listening that represent themselves pro se. If you go in there and just try to say he's bipolar, you're going to draw an objection from the other side, especially if they have an attorney. They're going to say you're not an expert, you don't have any evidence of that, and you're not going to get anywhere with it.
That's right. Andrea Sterling said, also, should we look into getting a lawyer? It is being enforced for him to pay child support, and he is currently unemployed. Even after filing out paperwork and sending proof, no income, we got enforcement letter today. You know, that's kind of a rough one, man. Even with COVID and everything that went on last year, it didn't seem like there was much relief for these parents that was out of work.
Most judges, and again, this is Arkansas. They do what's called imputing income to the paying parent. So even if they're not working, they'll say, we think you can at least get a minimum wage job. So they'll set child support at that level. So I don't know if that's what happened or not, but if he's unemployed for another reason, you might try to ask the court for some kind of relief, like if there was a COVID layoff or he's injured, or I don't know.
Yeah, absolutely. Ashley Borges said, why do states who make interference with child custody order laws, making it a felony when parents fail to provide children for court-ordered parenting time, never seem to enforce those orders? Why do parents still get told it is a civil matter when it exists as a criminal statute? And what can be done to hold those parties accountable?
Well, that's a really good question, Ashley, and it goes to what I was talking about before. And I think the way I worded it was, go talk to the prosecutor and try to get them to help you. Sometimes they don't. They do feel, I think as soon as they hear someone start talking about, he interfered with my visitation or she interfered with my custody or whatever, they immediately start thinking this is a domestic civil situation and go talk to lawyers about it. It's not a crime that a lot of times that they go after. I agree. And I don't have an answer to that because it is a statute. It is a criminal statute in pretty much every state. And if someone's violating it, something needs to be done about it. But if that happened to you, you're not alone. A lot of prosecutors just don't want to go after those kinds of cases.
Yep. Kimberly Dial said, my question pertains to the state of Georgia. If my husband is not allowed to exercise his visitation because the other parent interferes and checks the child out from school on the days that is his time legally, what can be done other than filing a police report?
I'm assuming that means like he's picking him up from school, but the other parent had picked him up early. Filing a police report is always good because it's nice to have that record. Understand, and I don't think a lot of people know this, but understand that in most states, certainly in Arkansas, police reports are not admissible. You could certainly have the officer come in and testify as to what you told them, but they are good to provide to the other side in discovery to show what you've been doing and what you've been keeping documentation of, and that you have a good, solid track record of your side of the case. But as far as checking them out early, again, that goes back to the order. That's a violation of the order. And a lot of people don't want to have to go back to court, or they hear about, I've got to file something with the court, and they start thinking of the stress involved with that, the money involved with having to do that and get an attorney. But unfortunately, a lot of the answers to a question like that is you got to go back to court. You got to hold their feet to the fire and ask for your fees. The judge won't always give it to you, but if you don't ask, you won't get it. So if they're truly in contempt and violating it, and you got to go back, try to ask for your attorney's fees.
There you go. Jeff Morgan on YouTube said, what are typical costs associated with a custody case? How many thousands of dollars?
That is all over the map. There is no set. And if you've gone and visited with very many attorneys, you've probably figured out real quick, every one of them has a different billing structure, retainer. It's based on experience of the attorney. I know when I'm asked to get on a case and quote a retainer, if the case has already started, I want to know who the attorney is on the other side, because some attorneys are much more difficult to deal with than others. I want to know how much history we've got, how many experts we're going to need. And all of those things can factor into how much a custody case is. I hesitate to even answer an amount because it's so different in every market in the country.
Yep. I've heard of people as low as $2,000 or $3,000 up until $2-3 million and above.
Yeah.
It's crazy, man. Jonathan Ford said, I'm in Florida. My son's mother made horrible false allegations. She ran away with him 2.5 years ago. She was recently disbarred. She knows the system. I can't get her served to bring her to court, which is how all this started because I initiated paternity action. I've spent $40,000 on PLS to no avail. I don't know what to do.
I think that may be PIs, maybe talking about private investigators.
Oh, yes, he was. Okay, it wasn't registering with me at the time. I'm sorry.
So I guess the mom was an attorney. She was disbarred. She knows the system. You got to try to find her. Now, most states, if she's really gone off the grid and you've made active efforts to try to find her, you can try to serve her through newspaper or other publications like that in your whatever your state statute calls for. Your attorney will know how to do that. But you have to, most states require you to make some kind of efforts and document those and show the court what you've done before you can use notification like that. But you should be able to proceed forward. If you spent that much on PIs and can't find her, I would think that's a good start towards showing the court you can't find her.
There you go. Merge Music and Film on YouTube said, question, if after 7 years parents are still in court due to mom's intractability and always, it looks like that might have got cut off. Get the rest of the question down there for me, man, and we'll get that going. Jacob Mateer said, if we are the United States of America, why are not all the states united under the same family law? Children need equality from both fit, willing, and able parents. That's a good question. Why is the law different in all states?
It is a very good question, and I think it's because we have I think a lot of the family laws are very, very old, and it goes back to when we started our country, and we divided up. And initially, we had each state's going to have their own little area and have their own rules. And I think part of it is that's the reason. But I think also our cultures are so different from different parts of the country. People up in the extreme Pacific Northwest may have different parenting styles, and things may be very different in their culture than they are in the South or in the Southwest or up in the Northeast. So I think that's part of the reason that it's still state by state.
Here you go. Jonathan Wanico, and I'm glad you wrote in, man. I remember reading his stuff. He's a native and on the reservation. A lot of that I know they got different laws and stuff there. But he said, I have a tough question. I have a judge on tribal land that isn't using evidence I have submitted to the state, which is seeing my side. I need help with either jurisdiction change or going federal. I don't know enough about law to move forward. I have shown my lawyers my paperwork and are questioning the judge's decisions. It's tough for me to afford a lawyer. Would you have any advice for him, Kevin?
No, and when it comes to tribal issues, I'm assuming he means he had a hearing in a tribal court.
Yep.
Yeah, I've never done that, and I know you say it's tough for you to afford a lawyer. I totally understand that. If there's any way you can find any kind of legal help, that's what you're going to need, especially if you're going to try to go federal or something like that, because otherwise the case will either get thrown out or you won't get off the ground unless you have some legal help.
Yep. And you know what, Jonathan, I'm going to try to reach out to some tribal lawyers because that's definitely something, I know it's a little bit different, but I will see what we can get going for you, buddy. And I hope everything works out okay. Stephen Cobb said, how to have the other parent privated? Children psych evaled? I guess maybe he's asking how to have them evaluated and get the children's psychological evaluations.
You just file it in the court. You need to get the judge to order that. And many times the judges will say, well, we'll just do mental evaluations on both parents if we're going to do it on one. So you may get that reaction, but at least you'll get the other parent evaluated.
There we go. iTumbler said, thoughts on using the final decision-making authority over education, location, and leverage of reducing child support. Go to mediation so nothing gets out to the judge about this? What's your thoughts on that, Kevin?
Final decision-making authority over education and leverage of reducing child support. Okay, so negotiating a final settlement and I guess trying to reduce child support, but giving up authority for choosing education. I mean, I guess that's just negotiation. These are a lot of the issues we talk about when we're trying to negotiate a final settlement. If you do it through mediation, then yes, it's confidential. No, whatever's brought up in the mediation is not to be used in court. I will tell you, pretty much all the states, I'm sure, settlement negotiations are always inadmissible. So if you are talking with the other side, you may want to put on there, this is a settlement negotiation and not admissible in court, so that there's no doubt about it.
Here you go. Stephanie Bradbury said, how do you suggest to address the alienating parent telling the judge child didn't want to go, parenting time, rejecting behavior?
Well, the first thing I always do is object to hearsay. Just because you're the parent doesn't mean you can talk about what the child told you. So a lot of that is hearsay. Now, you can testify about behaviors because a lot of times at visitation exchanges, one parent will, or both parents will talk about that the child is upset or didn't want to go. A lot of those things are just common, unfortunately, visitation exchange behaviors from a child. So you can talk about what you observed, but usually when you get into talking about what the child told you, that's usually hearsay and it needs to be objected to.
There you go. Thank you, Stephanie. Dustin Engelka, he said, will they enforce visitation for a 17-year-old? It's been 2 years since I've seen her. I asked my parenting time to be allowed weekend. I asked my parenting time to be allowed, I guess, on the weekends, but this seems so close to the end, that being her 18th birthday. Will they enforce visitation for a 17-year-old, Kevin?
The answer is yes. The issue you're going to have, and this is not an unusual issue, Dustin. It does come up when a child's about to be 18. It's how long is it going to take you to get into court? How long is it going to take you to get in front of a judge to get that addressed? And by the time you get into court, the child may be 18 and technically is a legal adult at that point and can kind of decide what they want to do. So that's really the answer is yes, they will enforce visitation on a 17-year-old, but you do have to wonder about the timing of it with the child about to be 18.
Absolutely. Merge Music and Film actually wrote his question back in. I appreciate that, man. He said, with parents in courts after 7 years due to one parent's controlling behavior and wanting to change contact from 50% to every other weekend, it's just nastiness. Best approach, child is thriving.
Parents in court after 7 years. So the other side's wanting to go from the joint arrangement of 50-50 down to every other weekend. Am I getting that right?
Yep.
I think the best approach is what you said in that very last sentence, child is thriving. When someone comes in and we've got a change of custody, I want to know how the child or the children are doing. And if they're thriving, going back to those factors we talked about earlier, if they're doing well in school, no behavior problems, no emotional problems at home, and they're really thriving, you have to show a substantial change in circumstances before you can change custody. Every state has a different phrase for it, but you've got to show things have really changed and gotten worse for the child one way or another since the last time you were in court before you can change custody. If the child's thriving, my argument would be there's no reason to change this, judge, and we need to change this situation, judge, and we need to leave it at 50-50.
Yep. Paul Hook said, what do you do if your child has reached the point of a pathological enmeshment, state of mind, and splitting is occurring to the point where the child will not make the exchange or get in the car or honor or acknowledge the visitation of the other parent? And that seems, and correct me if I'm wrong, Kevin, that seems like when you're talking about the different levels of alienation, that's in the severe level.
When I see that word enmeshment, I was thinking the same thing. You are going to, if you're in court or going to court, you're going to have to get again, all the documentation you've got to show what mom's been doing or the other side's been doing, but you're going to have some kind of expert come in and testify about the enmeshment because the judge is going to need to know what you're talking about when you bring that up. So an expert is who's going to be able to bring that all together for you and show the effects on the child and how this is happening and that it needs to stop.
Yeah, I'd agree, Paul. And that's, you got the mild, moderate, severe, man. If that's what's going on from what I'm reading, that's something you really need somebody to show that. So hang in there, buddy. I know that's got to be rough, my man. Kimberly Dial said, if the custodial parent doesn't allow you to pick up your child on your parenting time, what rights do you have other than filing a report?
We kind of talked about that earlier. You usually have to go back to court. Now, sometimes you can get a police officer or a sheriff deputy. If you take your divorce decree or your order showing what the parents are supposed to be doing, sometimes you can get one to go out and help you with making the exchange and making the other parent comply. It's hard though. Most of them don't want to get involved in that. So make your report, and if it becomes consistent behavior, then you just need to go to court over it.
Absolutely. Hi, here's a question we get a lot. Jeffrey Morgan said, do you believe custody hearings should be open to the public? According to the open court doctrine, the public has the right to know how the courts work and the right to observe the judge's behavior. You know, I'm a big fan of that, Kevin. I know there's probably some cases where details get really personal that it might not need to be. What's your thoughts on that?
I hate it that it's a tough question, because I know there's constitutional issues with having open courtrooms for things. Family courts can get so involved in very personal details of a especially if it's a divorce of a husband and wife's relationship. The children are involved. There's so many more personal things involved in family court than, say, in a regular civil case. There can be in a civil case too, but in family court, it's almost every case. I hear what he's saying about being able to observe a judge's behavior and that kind of thing. And we have a general policy in this country to be able to have the public view what goes on in our courts.
Yeah.
And you know, and you and I are paying that judge's salary and that courthouse's bills, and we should be able to go and watch things. But I don't know. I'm kind of back and forth on that as far as whether they should really be able to watch anyone in the public can go in and watch custody hearings or not. Sometimes I have an issue with it.
Yeah, I can understand. I guess that would be more of a case by case basis and making sure both parents agree to it. I believe they should let the parents decide on that, right?
Yeah, I think that might be a good decision.
Yep. Mike, I see your comment talking about your wife, man. I don't see if there's a question in there, but if you got one, throw it to us and we will get to it. Gabriela Torres said, if you have a court order in place for visitation, can the mother decide to take an extra day or change the time or location consistently?
Technically, no. That's a violation of the order. A lot of parents, and parents are most usually encouraged in these court orders to work together, because eventually something's going to come up that one parent or the other one has to change. So they want an extra day here, but I'll give you that day back at another time. Those things, you're supposed to work together if you can on that, but just unilaterally one parent saying you can't do this or can't do that, that's not supposed to happen.
There you go. Holly Gager said, why are there no lawyers to call to sue a county or a judge in family court?
Judges have an incredible amount of immunity, and they also have an incredible amount of discretion in the decisions they make. You have to show not that you just had a bad day in court, or not that you felt like you had several bad decisions throughout a case. I mean, you've really got to show extreme abuse and impropriety by a judge to try to sue a judge. They just have a lot of immunity.
Yep. Sean Saylor said, my ex tries to get a hold of my current girlfriend's family to, quote, get a hold of his son. She has my number and has done this type of thing for years. Is there something I can do to get her to stop that she spreads those rumors?
So she's trying to, okay.
If I'm picking that up right, is it your ex is contacting your girlfriend to tell you to get in touch with your son? That could be kind of a tough question, because I hope you're in contact with your son. If not, you know, I don't know if there's alienation or there's different rumors going on there. I tell you what, brother, Give us a little bit more details on that so I can get that question out.
Yeah.
Unless, I mean, maybe you see
Third
it from.
parties are the judges don't like it if third parties are trying to go around the parents with rumors or trying to interfere with the relationship or something like that. And I think that may be what he's trying to get at. But yeah, I need a little more info.
Yeah, if you could get that to me, man, I'll make sure to get that out there. Christopher Clark, I want to say thank you to Christopher for supporting the podcast. He said, I am a firefighter. If I was to get promoted to lieutenant, I have to be interviewed by City Board and Human Resource Office for approval. Is family court documents accessible to the public? My ex had filed some nasty, untrue affiliates throughout my case. I am afraid how my promotion could be viewed by my custody case.
Most family court documents in most states are accessible to the public. Yes.
Yep. So I hope everything goes all right with that, Christopher. Stephen Creasy said, what steps do I need to get some custody or something, or some kind of something to be able to have anything to do with my kid? I talked to a lawyer and she said I could go to court and either one of us would pay child support. Just when one of us has the kid, we use our money for the kid. But what steps do I need to take to get something like some kind of visitation or custody?
I just have to. Was this the paternity question from before?
Yes. Okay. So that makes a little bit more sense. I guess he's at the very beginning of this.
Yeah, you need to get to court and file for paternity. You need to get your legal rights established. And again, it's different state by state, but you need to make sure that you've got your legal rights as a father established.
Yep. Blue said, how do you prove allegation when kids are being alienated and don't tell the truth?
Well, this kind of goes back to one of the questions we had before about why are trial judges given so much discretion, and it's because they're able to watch the witnesses and they can make judgments on credibility, and that includes children. If children testify, if they don't testify, you're largely relying on an evaluator that did a mental evaluation or a custody evaluator or a GAL, a guardian ad litem. That's how you're going to prove it. You just got to really dig. You've just got to really dig in your discovery and preparing for court and get everything you can to try to prove that the alienation is going on and that the children are not necessarily being truthful.
Yep. Julie Pruitt said, what if you're held in contempt? You get 90 days suspended, but the papers you received aren't signed by a judge.
Well, there could be a bunch of reasons for that. I think the way I would answer this is if you get a contempt order, you're held in contempt, you get a contempt order, it should be signed by the judge and it should be file marked by the court clerk of where the case was. And if something doesn't have a signature of the judge or filed by the court clerk, I would go to the courthouse and check the case. It'll have a case number on the paperwork you've got. Go to the courthouse, ask the court clerk to see the file and see if it did get signed by the judge. A lot of times attorneys will send drafts of documents back and forth that look very official, but they're not signed. So the best thing to do is go to the courthouse and see if it was actually filed and if it's an authentic document.
Yep. Stephen Cobb said, I would like to talk to someone for a second opinion if you have free time. I have 2 attorneys and I'm fighting in criminal and now family. Thanks. How would he be able to get in contact with you, Kevin? Well,
you can go to our website, but there's some ethical rules on that. If you're represented by an attorney, you're not really, and another attorney is not really supposed to speak with you. We do get situations where attorneys will contact, or potential clients will contact us for second opinions, but it's a very slippery slope to try to do something like that. The thing I always encourage people to do, if they're having problems with their current attorney, set up a time and go visit with your current attorney and get a list together before you go in there. Because a lot of people are nervous about going and talking to a lawyer. It's kind of like going to the principal's office or something. And so they get in there and they forget all their questions. write them all down before you go in and ask your questions. And if you feel like your attorneys are not doing what you hired them for, you have issues with it, set up an appointment and go tell them about it and see what answers you get.
Yep. So I'm surprised we haven't got one of these before now, so I'm going to bring this to you, Kevin. Lee Carter said, Kevin, can you tell us more about John? Did he ever fear for his own safety, and how? How should we remember him?
I'm going to go to the last part first. You should definitely remember him as a great father. He was just a great, and Eric can speak to this too, he was just a great, mild-mannered, down-to-earth man. And the allegations against him were absolutely false. And anyone that ever met him and spent any time with him would know that this man just didn't have that kind of nature inside him. But he needs to be remembered as a great father, because he was, and he loved his children. That's the biggest thing I would say about him. He was a hard worker. He was a faithful man, and he loved his children and enjoyed his children, interacted with them nonstop when he was with them. He had concerns. I'm not going to specifically answer that question, but he had concern. This was a contentious custody case. And I think when that happens, you start to see sides of the other person that you used to either be married to or connected with that maybe you didn't see. Maybe you did, maybe you didn't. But, he had concerns about a lot of things.
Yeah. And, I found that conversation of John the other night, I didn't even know I had. And, maybe we can share that with you guys sometimes. I know one thing, when watching that the other night, John said that he wasn't just going to get through with his case and then let it go. John wanted to fight to make sure that nobody else like him, or went through things like he did, guys. And even though he was a quiet guy, he was until it came to these issues. He made sure that he spoke up and tried to get out there and fight. And I can tell you, I've talked to a lot of fathers, but John fought really hard for those kids, man. One of the hardest fights that I've seen. So
he did. And yes, he started trying to interact with groups that were involved with the legislature and vote, and locally where he lived and in other places, to try to get change for custody and visitation. He was just starting that process.
All right, guys, I'm going to try to get up to the questions just until this point, was we still got a good bit more. We've been going for about an hour, so I'm going to try to run through those really quick with Kevin. And like I said, we're going to be doing this every other week, so please come in here and show your support, and I appreciate Kevin for doing this so much. Nick Dion said, and I think this was earlier when he was talking about the step-parent getting involved, he said, also, what should I do about him being belligerent during exchanges, especially when he's not supposed to be present? I think he's talking about the stepfather.
If by saying he's not supposed to be present and that's in an order, then that needs to stop immediately. That's not something you play around with. And if he's ordered to not be around, there's a reason for that. And if he's violating it, there's something he needs to have some kind of repercussions with the court for that. So if he was belligerent and you were worried about it at the last exchange, you may need to start doing it at the police department. I would talk to your attorney about it, but that's not something to play around with.
No, and I think we was just talking about John. I mean, the murder of John happened at a designated meeting spot when he was supposed to be getting the children. So I think now more than ever, it's woke up a lot of people on those custody exchanges. So definitely take the advice that Kevin just gave you, man, because that's no small matter. It can escalate quickly.
That's right.
Eric Williams said, Kevin and Eric, when can you speak out of injustice on a long pending case if a judge seals the case? Secondly, is there any limit of time on an initial temporary order?
I'll kind of go to the second part first. Temporary orders usually end when the final order comes into play. So if the case is over, you'll want to double check with your attorney on that. But usually that means the temporary order is over with and the final order kind of supersedes that. Now, a lot of times we will refer back to the temporary order and the final order and say paragraphs 3, 4, and 5 we're going to keep or whatever. But other than that, the temporary order is usually over. When can you speak out of injustice? You really need to read the final order. If it was sealed, usually there's a good reason for that. It was either a juvenile case or it was sealed for some reason. And so you really want to be careful before you speak about a case like that that's been sealed. You probably want to talk to an attorney about that in your state, what the order says, the final order.
Yeah. Jacob Mateer said, what is considered domestic violence on your spouse? Before I filed, I've had things thrown at me. My son ripped out of my arms, marks on my neck from her when she ripped him from my arms. After filing for divorce, I was pushed around the house multiple times. She even ran my foot over with her car at an exchange while trying to drive away with our 2.5-year-old son's door still open. I can back up everything with the audio recordings as well as some video, which is legal in Indiana.
Well, all of those things may qualify. Every state's laws are different in their definitions of what qualifies for domestic assault and domestic battery. All of those things could definitely qualify. You would just need to go talk with the prosecutor about it, and they may tell you to go to the police first and file a report, but that's where you'd have to go.
Yeah. Kimberly had another question about the police when it comes to custody exchanges, and you call them, why don't they do anything? I think police are told to an extent that they're supposed to stay out of those matters. Is that correct?
Well, yes, and a lot of times looking at it from their side, a lot of times they get out to these domestic situations and they can't make heads or tails. You can give them your decree that says every other week. Well, they don't know whose week it is. The parents may, but the police don't. And I think that happens to them over and over. And they get to the point where they're like, we're not getting in the middle of this. You just need to get an attorney and go the civil route with it. At least that's kind of been my experience as to how their side of it.
Yeah. I understand what they're going through. It's like that too. We think we're supposed to call and nothing's getting done. I mean, we really need to get some more education out there for those guys and find out, Nick, I'm going to read something else from him because I know he's got a real, touchy situation going on. He said, also, I've been threatened several times by him and spat on physically, touched, and had the door of my van slammed by him all at the same time, and they have footage of this on their Ring doorbell. Is it possible to get my attorney to request this evidence?
Absolutely. I would subpoena it if it hasn't already been deleted. And you can take his deposition too and ask him about it. You can call any witnesses that witnessed it. You can call them to the hearing to testify about what they observed that he did. There's all kinds of ways you can prove that in court. That you need to be careful where you're doing your visitation exchanges.
Yeah, that's really got me worried, man. Luis Fargas said, I am disabled and I found out my ex-wife is doing drugs like coke, MDMA, which is ecstasy, and smokes a lot of pot and drinks a lot. I want to call CPS, but I am unable to care for all my kids, and I don't want CPS to take my kids. What should I do?
Don't call CPS. I don't mean that flippantly. I had a friend.
I hear you.
I had a friend that was a lawyer, and he had a great analogy, and he said CPS is like the old movies when the teenagers would put the pentagram on the ground and call up the demon spirit, but then they couldn't control it. That's kind of CPS. You can get them into your life, but you can't control what they do or how they get out of your life. If this kind of situation's going on, and you don't have a case filed right now, you probably need to file some kind of emergency motion with the court to try to get her visitation stopped until she can get drug tested and she can present herself to the court and show that she's off of all this stuff. But those are usually your only two options: is file an emergency, get an attorney and file an emergency motion, or go to CPS. That's kind of the only two options.
Yep. Steve Sharp said, how do judges handle parental interference and restrictive negative gatekeeping and poor co-parenting?
Well, if you can really prove it, most judges are not happy with it, not happy with it at all. You've just got to have a good set of evidence to present to the judge. And like I said earlier, you got to really show that roadmap of everything that's been going on and just how bad it's been. And my experience has been most judges will do something about it if you can show them all of that.
Yeah. Ashley Borges said, how does a parent avoid being labeled as highly litigious when they are forced to keep going back to court because the other parent violates the orders and refuses to co-parent or share information when the parties have been ordered joint custody and decision making?
Forced to keep going back to court because the parent violates the orders. Well, if the other parent's violating the orders and you keep showing that, most judges are going to get tired of that parent acting that way. And usually the repercussions are going to escalate. They'll usually initially warn them, then they may fine them, then they may make them start paying part of your attorney's fees. They will start trying to do things to get this parent to comply with the orders. So if you're the one having to do that because of the other parent's actions, I don't see how you would be the one that's labeled poorly there.
Yep. Holly Gager said, have you incorporated school interference in custody orders and FERPA violation in custody cases?
School interference. I have. You can put, especially if you come to an agreement, you can put pretty much any parameters in there and any provisions in there that the parties agree to. So yes, we've put things in orders about you can't come to the school till this day, or you can go to lunch. You can go and have lunch with the child any day you want to, as long as you give me a heads up by text or something, make sure I wasn't going to be there that day. I mean, you can put anything you want in an agreed custody order.
Right. I'm so interested in this question right here. I might have something to add to it, but I want to hear your thoughts on it first. All's Well on YouTube said, Attorney Hickey, have you ever had a male client pretend to be the victim of alienation?
Pretend to be the victim of alienation.
It was the alienator pretending to be the victim.
I will answer it this way. I've had cases where the client has come in and it's been pointing fingers the other way. And as we got into the case, I realized it was the other way around. I would answer it that way.
I'll tell you, man, I've had some of these conversations with people and something just don't click. A lot of the ones even in this community, I hate saying that because, we got a tight-knit community, but a lot of the ones here, even some of the experts in the organizations, man, it's like, I don't know what's going on here, but something just don't sit right with me. And a narcissist and an alienator is always going to be the victim, guys. Always. That's about the best I can explain that to you. Matthew Ryan Wright said, how you deal with narcissistic parents interfere court order FaceTime on the court order parent alienation, and laws creating a hostile drop-off, in-laws coming to drop off, I guess, the children.
It's hard to understand that. Let's see. Dealing with narcissistic parents, that's a tough one. You've really got to just try to get them to follow the order. And if they don't, they're not going to listen to you if you try to reason with them. If it's a true narcissistic parent on the other side, all you can do is try to hold their feet to the fire with the order that you've got. If you've got other people interfering, it says hostile drop-off, in-laws coming to the drop-off and asking, I guess, acting in a hostile way, you're going to have to put something in your order to keep other people from coming to your visitation exchanges. That's about all you can do.
Yep. And guys, I'm going to skip on some of these questions because we've been hearing from a lot of you repeatedly. I'm going to try to get to some of these guys' questions because we're getting close to an hour and a half here, and I know I don't want to keep Kevin up all night.
That's all right. For a while.
Melinda Gore said, are there any standards for requirements that an attorney is assigned as a guardian ad litem is expected to report concerns of safety and threats of harm to others? Our gal failed to report awareness of a threat to cause harm, attempting to hire someone to beat up and kill the other parent. Lord have mercy.
Wow. I'm a little hesitant to answer that. I think I can answer that generally. Standards for requirements that an attorney is that is assigned as an ad litem is expected for report concerns. That's an ethical that's a sticky situation ethically. I think it would depend on who the report came from. If the report came from their client, which is the child, I don't know on that. I think most attorneys feel a duty, though, if there is a genuine threat of something like that, of a crime that's about to be committed. I think I'm speaking a little out of turn. I haven't researched that on the ethics rules a long time, but I think you may have some kind of duty to report that or prevent it from happening. But I'd have to ask one of my ad litem friends about that one.
Yep. Hey, Melinda, we'll be back in 2 weeks. Bring it back to Kevin. Randy,
hey, Eric, will you save that one and send that to me when we're done? I want to look into that.
I'm going to take a snapshot with my cell phone. It's probably the easiest way to do it. We care about you guys' questions. All right, got it. All right, we'll find out for you, Melinda. Randy James Davis said, I have a psych eval coming up, and the temporary orders say it's not to be released to the court. What is the point in that?
Well, sometimes the psych evals will go to the attorneys. Sometimes the judge will order it and say that they want it sent to the court, so the judge will have it, and sometimes they'll order it and say it goes to both attorneys, so they'll have it. You'll need to talk to your attorney. That doesn't necessarily mean it won't show up in court someday. So I think it just means don't send it directly to the court. That's the way I read it, but I haven't seen the order.
Yep. Lee Carter said, am I correct? Parental alienation isn't recognized by the American Psychology Association, and hence many courts don't recognize it as an occurring event. I know alienation is in the DSM, but it's under a different name. I can't remember the name, but I think, and Kevin, we was talking about this not long ago. I think so many parents get stuck on wanting to prove parental alienation when they need to be exposing the behaviors.
Absolutely. And I have never cared really. Alienation is just a phrase that we use a lot of time because most people are familiar with it and know what it means. I don't care much what it's called. You got to show the behaviors of what's going on. And the courts will recognize it as an occurring event. If they see what we call alienating behavior by a parent, and whether it's recognized by the American Psychology Association or not, they're probably going to do something about it.
Right. Matthew wrote back. He said, how do you deal with the in-laws contributing and involving themselves with the alienation? Sometimes I'm only talking for 5 seconds and the whole week until I see her.
Well, again, something's got to be done about third parties trying to interfere with your visitation time. And if that's not in your order, you may need to go back and have it looked at.
There you go. Nikki Ward said, how likely will a judge change to 50-50 or change of full custody if 3 out of 4 kids failing in school?
I can't give you an answer on that. There are so many factors that go into a judge's decision on custody and visitation. I can tell you, if 3 out of the 4 children are failing in school, that is a factor that the judge is definitely going to be concerned about.
Yep. Stephanie said, how do you get the judge to understand that this is a child protection issue?
I think she means that the child's in danger, maybe. You're going to have to have evidence of it. We were talking earlier about just because the other party put that in a writing and filed it with the court as their allegations doesn't mean it's true. They're going to have to go and prove that. You've got to prove your side too. And that's where you really need your attorney to assist you, because a lot of information you have, it's not just automatically admissible because it's on a text message or in an email. There are evidence rules that can keep it out, but your attorney will know how to get around that and get those in and make sure they're not hearsay, that they're authenticated properly, and that the judge can see them. The way to get the judge to understand it is to keep all of the evidence that you can that there's some kind of child endangerment going on, and then present all that, get it into evidence somehow.
I think the importance of that with the situation that we've been talked about, if they took stuff like that, John never would have been exonerated. And there was
Yeah.
a guy that proved every way up and down, his innocence. So,
Yeah.
um, Steve Sharp said, I have 3 daughters ages 17, 15, and 11, only every other weekend physical custody. I understand that first right of refusal is not needed for teenagers. However, custodial parent uses oldest child as replacement parent, as well as hired child care providers when father is willing and available to parent. How do judges look upon this? Would a first right of refusal be appropriate?
Possibly. First right of refusal can be a good thing and it can be a very bad thing. What are we've started having to put parameters on it. And first right of refusal, for people who don't know what that is if one parent needs um, a babysitter or something like that for the children, they're supposed to call the other parent first and give them the first right to be able to watch the children. Well, what does that mean? If you're gone for 2 hours, if you're gone for 3 hours, if you're gone for 30 minutes to the store, what if your parents, which are the children's grandparents, are coming over to visit with them? Does that mean you're supposed to call the other parent? If parents are able to get along, then a first right of refusal can be a very good thing. But if they're not, and it's been very contentious, I've seen it become an area of a lot of frustration and fighting back and forth just because they're not one side says the other one's not complying with it.
That's right. Lex Sari said, my ex has filed for full custody based on communication issues and that the children suffer due to my inability to work with her. How do I tackle these false accusations?
You're just gonna have to show that you're communicating, that there aren't communication issues, and that the children are not suffering. Again, those are allegations that they've got to prove, and you've got to show your side that that's not what's happening.
There you go. Corey Ritter said, hey, Kevin, I'm curious, how do you cope as a family law attorney dealing with severely unethical and unjust rulings? For example, a judge has a relationship with an opposing attorney or neutral evaluator and is not impartial because of those relationships.
Well, he's just talking about, you're talking about some really, basically inappropriate behavior by a judge and an attorney. They're not supposed to have that type of a relationship going on. But yeah, I'd be pretty upset about it. I mean, if something like that was going on in a case and I found out about it, I wouldn't be very happy about it at all. I can tell you, I can't remember the time that something like that happened. But if it did, yeah, I'd be pretty upset about it.
Yep. Jeremy Lanin said, Kevin, I have an attorney. I also was appointed a gal in my case who works closely with my daughter's untrained therapist that my ex started taking her to. The therapist is who got defects involved with false allegations. Then the therapist didn't even bother to show up to the defects hearing as the star witness whom was subpoenaed by Department of Children and Family Services. No show, no call. Defects final report states I'm a fit, loving parent who is a victim of PA. My attorney says I can't use this document in court. And the question cut off there because it was a little bit long. But
the reason I think he's talking about the document that exonerated him. It looks like their final report. It says he's a fit, loving parent, who's a victim of parental alienation. His attorney may be saying he can't use it because it's hearsay unless he can bring whoever drafted the report to court to authenticate it. Otherwise, I'd be trying to use it. But again, and that's why, I hate second guessing attorneys when I see something like this, because I'd like to hear their side of it, why they think that. There's got to be some evidence rule that they're concerned about is the thing that I'm thinking of, because otherwise I'd be trying to get it into evidence.
Yep. Brandon Bickelhopt said, what if nothing happens with contempts?
Well, Brandon, that's a good question. And it's very frustrating for clients and it's very frustrating for attorneys as well. Some judges, it's hard to move the needle with them to really get them to do I'm assuming he's talking about he's filed for contempt over and over, and the judge that he's dealing with isn't doing much about what the other parent is doing to violate the order. All you can do is keep chipping away at it, and keep notifying the court and keep filing with the court and showing this pattern of poor behavior. That's about all you can do. But the judges have a lot of discretion in the punishments that they give out for contempt, anywhere from a slap on the hand to throwing them in jail, and attorney's fees and fines, anything in between. And you just have to try to keep chipping away at it.
Jeffrey Sandzone said, what should you do if your ex's boyfriend won't leave after she breaks up with them and your 5 minor children are in the household at times? Me and the ex are on good terms, especially for the kids.
I'm not hearing, any abuse going on.
Him and the ex are actually on good terms, and she's broke up with the boyfriend, and he won't leave the house. And this man's kids are in that house that the ex-boyfriend won't leave.
Right. Well, if he's causing some kind of danger situation, you may have to, if you're on good terms with your ex, I'd let her know, look, if you're not going to do something about getting this guy out, I may have to file something. I don't know what else you can do. I didn't see anything where he's abusing the kids, but I'm assuming it's not a very good situation in the house.
Okay. All's well on YouTube said, question, California now setting the law, including coercive control as a circumstance to receive a restraining order. Have you seen it in action yet?
Don't think I have. No, I've not seen that.
Yeah. Mike Edwards said, I have video and audio of my wife during outbursts and antagonizing kids. Divorce is nearly final and she is still doing it. I have my reasons for backing off during process. Does my evidence still have credibility? I have several years of it.
Video and audio blocking. Yes. Divorce is nearly final, which to me means there's a final hearing coming up at some point. You're going to have a chance to show all of your evidence. Absolutely, it still has credibility. I don't know that, and your attorney may tell you you're not going to get a judge to listen to several years of it, but yeah, you could definitely use it. And I'd talk with your attorney about what parts of it you want to use at the hearing.
Gotcha. Amy Harold Snyder Johnson said, we had a judge keep us from our kiddo during COVID-19 for over 100 days when the governor and head judge said no judge could do this. We are now facing this again. Is there anything we can do to prevent this from happening again? We don't live in the same state as the child. The head judge ruling and governor ruling is in the state the kids is in. How is it that judges don't have to follow these orders? I saw a lot of this during COVID.
We did too, in the state of Arkansas. I think all states came out and made it pretty clear that you can't use COVID-19 as an excuse to deny visitation. I don't know what's going on with your case right now, but I would be trying to point out to the judge that at least the governor, and I'm wondering if the Court of Appeals in the state that she's in issued a mandate about COVID-19 not being used as an excuse to end visitation. You show that to the judge, that should get it done. I don't know why the judge would not follow that.
iTumblers on YouTube said, Dad Talk, have you or Kevin's clients do anything strategically that help turn the court into your favor? I am not a lawyer. I just do a podcast. So I don't have any clients. I have you guys, and I love you. Thank you for being here. But how about you, Kevin?
The best thing, and I think I get the gist of the question, strategically, how do you help get the court on your side or rule in your favor? And the best thing you can do is present the best case that you can. You want an orderly presentation of evidence, your witnesses, your documents you're going to use, your arguments as to why you have the better case, and be as truthful and honest with the court, and make an honest presentation. The more genuine you are, the better. Judges, after a bit of time on the bench, become not necessarily experts, but pretty darn close at judging people and judging credibility of people. And if you're going in there as the truth tellers and you got it backed up with witnesses and you got it backed up with documents and evidence, then that's the best thing you can do.
There you go. Christopher Clark said, what co-parenting application do you recommend? Can you give your lawyer full access to the site to stay up to date and in the know? Keep track of dates, funds, documents. Should this be a default order from conflicting cases?
I don't know. The only one that I really hear of on the co-parenting application is Our Family Wizard. The people that I know that have used it have liked it. Now, I may have a bunch of clients call me tomorrow and tell me they don't like it, but that's the one that I hear most parents use and that seems to be the most popular. There is a charge for it. I think it's, well, I don't know how much it costs, but there is a charge for it. The lawyer having full access to it is very interesting because I encountered a case in another state. I think this was in the Minnesota case where the ad litem and the attorneys could actually sit in and watch these conversations between the parents. And I was a little shocked by that. Usually you don't ever have access to what the other side is saying as an attorney. So you may want to check your state and see if they allow you to be part of those conversations on the co-parenting
app. Stephen Valarezo, I hope I said that right, my man. He said, my wife and I are separated after 5 years, and I have no clue where she wants to go with all this. She's not a crazy person to put me on child support or anything, but should I be well aware of something? What should I do?
Go with one.
It looks like he's about to go through a divorce. What should he be aware of?
Well, you just need to talk to an attorney because you never know. You never know if your spouse has already spoken to an attorney or is taking steps to get ready for divorce. The biggest thing that I always get concerned about, and one of the questions I get a lot from a new client, is what should I be doing? And the biggest thing that I tell them is if you have any joint accounts with somebody, always remember either person that is on the joint account can withdraw the whole thing if they want to. So you have to watch for that. So I tell people to either monitor that account or set up a separate account for their payroll checks to be going into or whatever while the divorce is pending. Now keep track of that. Don't hide money or anything, but it's a preventative measure to keep the other side from just taking everything out of the account.
Yeah. Jonathan Wetzel, I see your comment, and he was saying refer to some of the other comments. Man, they're so broke up, I don't have time to go piece them together right now. But man, like I said, we will be back. So if you don't get it in tonight, guys, don't worry. We will get to it. John Knight said, have you ever heard of a judge dismissing arrears?
I think that means child support arrears.
I think so, yeah. Mm-hmm.
It can happen, yeah. Have I heard of it? I can't think of a case offhand, but a judge could potentially do that in certain situations. Usually it might be some kind of offset, something new that's happened, either custody's changed and now the other parent owes child support or something like that. I guess it could happen. I just have to know more.
Gotcha. I already know the question to this, and I think they do too, but they want to ask you anyway. Bridget Shamblin said, are the rights for the unwed father equal to the mother's rights?
In most states, in Arkansas anyway, no. You need to file a paternity action to get your legal rights established as a father.
Yep.
Right. Wait a minute. Yeah, unwed father. Yeah, okay.
All right, guys, I think we have made it down to the very bottom. I skipped over a few of your questions because I got in some questions from the same people, but we'll be back. Kevin, I appreciate it so much, man. Now correct me if I'm wrong, then when you worked on John's case, I know you're out of Arkansas, but isn't there some law like pro havice or something like that where you can go and work with the local attorney?
Yeah, pro hoc vice, and that's one thing we do is on highly contentious custody cases. I can take those cases anywhere in the United States. We will usually co-counsel with a local attorney, and you get admitted. It's called pro hoc vice. You get admitted to practice in that state for that case. And so we do take those cases anywhere in the country.
Gotcha. So tell everybody, if they wanted to keep up with you or wanted to reach out to you about something, where can they find you?
KevinHickeyLaw.com is our website. You can find us there. You can find me on Twitter at Kevin the Lawyer. I'm on Instagram. I think that's also at Kevin the Lawyer. And we have pages on Facebook. Kevin Hickey Law Partners, Northwest Arkansas. We have an office in Rogers, Arkansas. And then we have Kevin Hickey Law Partners in Fort Smith, which is the office I've been at for several years. But that's how you can find us. Oh, and let me give the phone numbers, 479-434-2414.
All right, man. And I'm sure, guys, as soon as we get some more information about that, John, we'll be on here telling you about that as well. But Kevin, man, I appreciate your time so much and thank you for coming on here. And guys, if you got some questions, we'll get to you next time. Let's plan on this. 2 weeks from Monday. Sound good, Kevin?
I'll be there, man.
All right, guys. We'll see you next time.
Thank you for joining us tonight. We are fighting for the rights of parents worldwide. If you want to help support our podcast and for us to continue this mission, please join us at patreon.com/dadtalktoday. You will find us on Facebook, YouTube, Instagram, Twitter, CloutHub, Parler, iHeartRadio, Stitcher, Spotify, the podcast app, Google, Apple Podcasts. We're a little bit of everywhere. And guys, every time you like and subscribe, you help us continue this mission. Thank you, and we will see you next time.